by deleting paragraph A and substituting therefore the following new paragraph. A, granting of loans or credit facilities, whether or not digitally, to members of the public or a section of it, with or without interest, and either secured or unsecured on the goods or assets purchased. And 2, by inserting the following proviso in middle paragraph F, provided that this does not include any credit arrangements involving the provision of credit by a person that is merely incidental to the sale of goods or provision of services by that person. And B, in paragraph B, by inserting the word credit immediately after the word taking in definition of the term credit provider. Honorable Chair, this amendment is seeking to expand the definition of non-deposit taking credit business to include granting of loans or credit facilities digitally. This covers the non-deposit taking credit businesses which operate digitally but are not covered under the CBK Digital Credit Providers regulations and are therefore unregulated. And this is also going to limit the definition of a non-deposit taking credit business to exclude businesses such as Safaricom, which sell their products such as phones through credit. So, Honorable Chair, this is to include the non-deposit taking digital lenders into CBK Act so that they can under the purview of CBK, so that rules such as where interest should not exceed the amount of principal now will become law. And therefore, the pain that our border people and all those others have been going through, where they actually get to pay interest that is higher than the principal amount, does not exist. But also to exempt those that also give credit in their line of business. So, for example, if you're in the fuel business and your supplier supplies with you with credit, then that credit will not come under the purview of CBK. I beg to move, Honorable Chair.
I now propose the question that clause 4 be amended as proposed by the Honorable Kimani. Yes, Ishima.
Thank you, Speaker. I think, Speaker, I would like to contribute to this proposal because since CBK published the rules regarding deposit taking or other digital credit providers, which is, I think, about 3 years ago, they've only managed to license about 51 out of 280 applicants. And I am surprised that this House would allow CBK to bring an additional maybe 200-300 microfinance, which sit under the Association of Microfinance Institutions in Kenya, which has been opposing this bill, into the purview of CBK. So, Speaker, financial intermediation is a liberalized market just like any other. Just like selling clothes, just like selling shoes, it's a willing buyer, willing seller. There is, of course, what sits under the ambit of regulated financial intermediation, which is at the banks, SACCOs, especially the people who are taking deposit. But anybody lending their money in an open market, Mr. Speaker, I do not think that it will be wise for this House to bring them under the ambit of the Central Bank of Kenya. And Mr. Speaker, I think we could be killing innovation in this country in the name of regulation. I know there is this blanket condemnation of Shylocks, of I don't know, any financial intermediator, being branded as predatory and things like that. But Speaker, I would like to tell you that the people who go for these loans is not because they have gone to a bank and have asked for a loan and have been granted. It's because our banks, our SACCOs, some of the rules that they have leave a huge population of this country outside the formal credit access mechanism. So, Mr. Speaker, I urge this House to reject any attempt at strangling financial intermediation through undue and unnecessary regulation. I submit. Speaker.
Yes. Who is on a point of order?
Chair, I really want to implore on you again, please guide the House that we are in committee of the whole, not in second reading.
In committee of the whole, there is also
not second reading, Chair. Chair, if you allow me to correct what the Honourable Member for Tetu is saying, Honourable Andeto. One is presupposing that by bringing these institutions, microfinance institutions, under the ambit of regulation by CBK, they are being transformed into banks. They are not. They are just being regulated for the purposes of regulating them to ensure that the young border riders in Tetu constituency are not taken advantage of by crooks. Because some of these people are simply crooks who are not being regulated by anybody. They are vending money. You cannot tell us that the business, that is why that the business of selling money is the same as the business of selling clothes. No, Honorable Andeto, it is not. That is why you cannot even register a company with the name finance without, or capital, without the approval of central bank. Honorable Speaker, but please, Honorable Speaker, guide members in the third reading. No?
Fair enough. The Honorable next to Langat, Benjamin Langat.
Thank you, Chair. In support of this proposal, one thing we must always remember is that we must protect the interest of the public.
Absolutely.
And in protecting the interest of the public is supervising the industry. Anyone who wants to deal with money, finances, loans, advances, or credit must bring themselves to the purview of CBK so that they are controlled. And in being controlled does not mean that they are being stifled. They will still be innovative within that sector. They will still carry out business within that sector. They will remain vibrant and serving the sector that they want to serve. But they must accept to be controlled and supervised. You made your point.
Marianne, did you raise your hand, Marianne? Oh, no, I'm looking for a lady who has raised her hand. Okay, proceed, Marianne.
Chair, I want to support this amendment because this amendment is going to save that Mama Mboga in my constituency who wants to borrow money and does not want to borrow money from somebody who is going to charge them exorbitant loans, and they are not regulated. They do not fall under any armpit of any regulation. Any business that we do in this country must fall under regulation, and you must abide by the rules of the law. So this amendment is actually securing anybody who is going to borrow loans or anybody going to borrow money. Thank you. I support.
I think there is a consensus. Makilap, the last one. Makilap, I'm good of the House.
Chair.
Yes.
The essence of committee or parliament going out to look for the people of Kenya is to listen to the voice of the people of Kenya. The people of Kenya are saying these unregulated financial digital lenders are actually killing the people of Kenya. It is become a scam. Mr. Speaker, we support the report of the chairman of finance because if we don't regulate, they will actually wipe out people in business.
Honorable
we must
members,
kill those.
Honorable members, I now put the question that clause 4 be amended as proposed by the Honorable Chair of the Finance Committee. As many of opinion say aye. As many contrary opinion say nay. The ayes have it. I now put the question that clause 4 as amended be part of the bill. As many of opinion say aye. As many contrary opinion say nay. The ayes have it.
Clause 5.
Clause 5. Chair.
Honourable Speaker, I beg to move that clause 5 of the bill is amended by inserting the words of Kenya immediately after the words Central Bank in the opening statement, deleting paragraph C and substituting therefore the following new paragraph in paragraph 8 by deleting the word digital appearing before the word credit in subparagraph 7 and substituting therefore the words non-deposit taking. And lastly, inserting the following new subparagraph immediately as subparagraph 8, that is 8A, credit guarantee companies. This, Honorable Speaker, is to correct a typographical error in the citation of the Central Bank of Kenya Act. What is contained in the bill is the Central Bank Act, but the Matham Act is the Central Bank of Kenya Act. So you're adding the word Kenya. And a cleanup of the act by deleting the word digital, which is substituted by the word non-deposit taking as per the new proposed definition. I beg to move, Honorable Chair.
I now propose the question that clause 5 be amended as proposed. I now put the question that clause 5 be amended as proposed. As many of the opinion say aye. As many of the contrary opinion say nay. The ayes have it. I now put the question that clause 5 as amended be part of the bill. Will as many of the opinion say aye? Will as many of the contrary opinion say nay? The ayes have it.
Clause 6.
Honorable Kimani, proceed. I propose the question that clause 6 be part of the bill.
Honorable Chair, I beg to move
Chair of Finance, yes, move.
Honorable Chair, I beg to move that
Move the amendment.
that clause 6 of the bill is amended by inserting the word of Kenya immediately after the word central bank, and this again is as I explained earlier. The Mother Act referred to as the Central Bank of Kenya Act, not Central Bank Act.
Okay, I propose the question that clause 6 be amended as proposed. I now put the question that clause 6 be amended as proposed. As many of the opponents say aye, as many of the contrary opponents say nay, the ayes have it. I now put the question that clause 6 as amended be part of the bill. Will as many of the opponents say aye? Will as many of the contrary opponents say nay? The ayes have it.
Clause 7.
I propose the question that clause 7 be part of the bill. Move the amendment. The Honorable Kimani.
Please.
Honorable Kimani.
Yes, Honorable, it is the majority leader and the MP for title who are consulting in a very loud voice that we need to protect me because we need to pay attention to what you're doing.
Honorable Ichungwah and Honorable Wandeto. I know you are debating a matter that is already functus official. It's already gone. Proceed.
Honorable Chair, I beg to move that clause 7 of the bill is amended by inserting the words of Kenya immediately after the word central bank in the opening statement, and B in the proposed section 33R by deleting the expression section 4A DA and substituting therefore the following new expression section 4A1 DA appearing in the opening statement. This amendment is seeking to correct a typographical error in the citation of the Central Bank of Kenya Act as explained, and a reference error which references section 4A1DA, which is proposed to be amended. I beg to move, Honorable Chair.
I propose the question that clause 7 be amended as proposed. I now put the question that clause 7 be amended as proposed. As many of the opponents say aye, as many of the contrary opponents say nay, the ayes have it. I now put the question that clause 7 as amended be part of the bill. Will as many of the opponents say aye? As many of the contrary opponents say nay, the ayes have it.
Clause 8.
I now propose the question that clause 8 be part of the bill. Proceed, Honorable Kimani, move your amendment.
Honorable Chair, I beg to move that clause 8 of the bill is amended by inserting the words of Kenya immediately after the word central bank, as I explained. Again, it is correcting a referencing error to the Mother Act.
I now propose the question that clause 8 be amended as proposed. I now put the question that clause 8 be amended as proposed. As many of the opponents say aye, as many of the contrary opponents say nay, the ayes have it. Clause 9. I now put the question that clause 8 as amended be part of the bill. Will as many of the opponents say aye, as many of the contrary opponents say nay, the ayes have it.
Clause 9.
I propose the question that clause 9 be part of the bill. Chairman.
Honorable Chair, I beg to move that clause 9 of the bill is amended in the proposed new section 33X in subsection 2 by inserting the following new paragraph in paragraph D, by inserting the following new paragraph after paragraph C. Now a new paragraph D, that is a bank providing credit guarantee as part of its regular banking business regulated by the Banking Act, and 2 in subsection 4 by inserting the words without a license immediately after the word business. This amendment, Honorable Chair, is seeking to exempt banks which already provide credit guarantee as part of their regular banking business from the requirement of registering as a credit guarantee business, and correction of an omission in the offense which has been established under the clause. By adding this new concept of credit guarantee, we are exempting banks that already are providing credit guarantee business to having to register again in the Act. I beg to move, Honorable Chair.
If you look at the order paper, supplementary, 3478, in the same clause, I think there's something you left up. There's a typo, paragraph A. Clause 9.
Oh, yes. Honorable Chair, again, I also beg to move that clause 9 be amended as per the order paper by inserting of Kenya immediately after central bank. And this is again the same.
Absolutely.
For the same reason that I've explained again.
Honorable members, I propose the question that clause 9 be amended as proposed. Honorable members, I now put the question that clause 9 be amended as proposed. As many of the opinion say aye. As many of the contrary opinion say nay. The ayes have it. I now put the question that clause 9 as amended be part of the bill. Will as many of the opinion say aye? Will as many of the contrary opinion say nay? The ayes have it.
Clause 10.
Honorable members, I propose the question that clause 10 be part of the bill. The Honorable Kimani, move your amendment.
Honorable Chair, beg to move that clause 10 of the bill be amended by inserting the word of Kenya immediately after the word Central Bank of Kenya for the reason I have explained again.
Honorable members, I propose that clause 10 be amended as proposed. I now put the question that clause 10 be amended as proposed. Will as many of the opponents say aye? Aye. Will as many of the contrary opponents say nay? The ayes have it. Honorable members, I now put the question that clause 10 as amended be part of the bill. Will as many as of that opinion say aye? Aye. Will as many of the contrary opinion say nay? The ayes have it.
Clause 11.
I propose the question that clause 11 be part of the bill. Chairman, move the amendment.
Honorable Chair, I beg to move that clause 11 be amended in the opening statement by deleting expression 57.3 and saying therefore with the expression 57, and in paragraph H by deleting the expression subsection 1 appear immediately before the words by substituting therefore the expression in subsection 3, and C by renumbering paragraph H as paragraph A, and D by renumbering paragraph I as paragraph B, and E by renumbering paragraph J as paragraph C. And these are just to correct typographical error and to ensure good flow of the bill.
Honorable members, I propose the question that clause 11 be amended as proposed. There is nobody who is interested. Okay. I now put the question that clause 11 be amended as proposed. Will as many of the opinion say aye? Will as many of the contrary opinion say nay? The ayes have it. Honorable members, I now put the question that clause 11 as amended be part of the bill. Will as many as of that opinion say aye? Will as many of the contrary opinion say nay? The ayes have it.
Clause 12.
I propose the question that clause 12 be part of the bill. Chairman.
Honorable Chair, I beg to move that clause 12 be amended as per the order paper. Again, this is to correct the referencing error of Central Bank to Central Bank of Kenya Act.
I propose the question that clause 12 be amended as proposed. I now put the question that clause 12 be amended as proposed. As many of the opinions say aye, as many of the contrary opinions say nay, the ayes have it. I now put the question that clause 12 as amended be part of the bill. Will as many as of that opinion say aye? Will as many of the contrary opinions say nay? The ayes have it.
Clause 13.
I propose the question that clause 13 be part of the bill. The Honorable Chair of the committee.
Honorable Chair, I beg to move that
move the amendment. Yeah.
Clause 13 be amended as per the order paper. This amendment is speaking to clean up the bill by removing the proposed new definition, which is incorrectly referenced to the Movable Property Security Rights Act.
I propose the question that clause 13 be amended as proposed. I now put the question that clause 13 be amended as proposed. As many of the opinions say aye, as many of the contrary opinions say nay, the ayes have it. I now put the question that clause 13 be amended, as amended be part of the bill. Will as many of that opinion say aye? Will as many of the contrary opinion say nay? The ayes have it.
Clause 14.
Honorable members, I propose the question that clause 14 be part of the bill. Kimani? There is no amendment on clause 14. Yes. I now propose, I now put the question that clause 14 be part of the bill. Will as many of the opinion say aye? Aye. Will as many of the contrary opinion say nay? The ayes have it.
Clause 15.
Honorable members, I propose the question that clause 15 be part of the bill. The chair move your amendment for clause 15.
Honorable Chair, beg to move that clause 15 be amended as per the order paper. This amendment is seeking to correct. This amendment is seeking to correct a typographical error in the bill by replacing the word finance with microfinance.
I propose the question that clause 15 be amended as proposed. I now put the question that clause 15 be amended as proposed. As many of the opinion say aye. As many of the contrary opinion say nay. The ayes have it. I now put the question that clause 15 as amended be part of the bill. Will as many of the opinion say aye? Will as many of the contrary opinion say nay? The ayes have it.
Clauses 16, 17, and 18.
I propose the question that clause 16, 17, and 18 be part of the bill. I now put the question that clauses 16, 17, and 18 be part of the bill. Will as many of the opinion say aye? Will as many of the contrary opinion say nay? The ayes have it.
Clause 19.
Honorable members, I now propose the question that clause 19 be part of the bill. Kimani,
Honorable Chair, I beg to move that clause 19 be amended as per the order paper. This amendment is seeking to expand the obligations of the non-deposit taking microfinance business in consumer protection by ensuring that they furnish information on the procedure of both lending and recovery, as well as adherence to the right to privacy enshrined in the Constitution and statutes. Honorable Chair, this is seeking to correct, Honorable Chair, where we have had some creditors call your parents, call your brothers, call your sisters, call all the people in your phone book when there is a delay in payment. So to make sure that they, even as they lend, there is full disclosure of how they are going to recover in the event that the loans are not paid, and also to ensure that the protection of the privacy of the borrower is protected.
I now propose, yes, the Honorable Makalimul. Honorable Makalimul, I propose the question that clause 19 be amended as proposed. Proceed, Honorable Makalimulu.
Yeah, thank you very much, Chairperson. Chairperson, I want to support this amendment, and I do agree with the Chairperson of the Committee on Finance and Planning, because this is one of the most abused, actually, clauses in terms of information. We have a Data Protection Act, Honorable Chair, which protects all Kenyans, including those who are borrowing. But a number of times this has been abused, and I think we really need to ensure that this clause, after it becomes law, is actually enforced. With those remarks, Honorable Chair, I support.
The Honorable Oundo.
Chair, and I want the Chair of Finance probably to shed some bit of light here. Chair of the Committee of Finance. We are talking about information sharing. To what extent does information shared by Credit Reference Bureau interface with this particular provision? Credit Reference Bureau, as I support, we need clarification, sharing information with Credit Reference Bureaus, so that we are very clear, Kenyans are very clear, that yes, you can share information to a certain extent, but well, what are the limits? So that we need to, Kenyans can be aware.
Yes, the Honorable Kajwang Otieno.
Yes, together with, what
TJ.
the Professor is asking. Mr. Chair, although I agree with the principle of this amendment, but this amendment is not necessary. I can see it is 2A. Is it 2A? 2A. I mean, everybody is enjoined to adhere to the Constitution. And everybody is enjoined to adhere to the Data Protection Act. So a law which simply reminds people to adhere to the law in legislative practice is superfluous. So I think we need to agree here that we are not reproducing laws just for the sake of it. Chair of Finance, it escaped you that everybody in this country should respect the Constitution and should respect the Data Act, which is already there. So all you are doing is to reproduce that law. I agree with the principle, but in terms of legislative practice, I don't think I like this type of legislation.
Anybody else who wants to take a bite at it? I now put the question that clause 19 be amended as proposed. As many of the opinions say aye. As many of the opinions say nay. The ayes have it. I now put the question that clause 19 as amended be part of the bill. Will as many of that opinion say aye? Will as many of the opinion say nay? The ayes have it.
Clause 20.
I propose the question that clause 20 be part of the bill. Where is the majority leader?
Honorable Speaker, I beg to move that clause 20 be amended as is on the order paper.
Proceed.
Was this yours or mine? Huh?
It's on page 3475.
Sorry, Honorable Speaker, because we had two amendments. Honorable Speaker, all we are doing is to require that the Kenya Bureau of Standards, that the Bureau may liaise with relevant government agencies which register businesses to obtain information on businesses registered to undertake manufacturing. Honorable Speaker, the committee had sought to delete a provision in the bill that required disclosure of certain information for manufacturers, or rather requiring manufacturers to register with the Kenya Bureau of Standards, and to dissuade the Kenya Bureau of Standards from increasing the cost of doing business. We have now amended that the Bureau will now be required to liaise with other relevant government agencies like KRA, the Bureau of, it's called what? The Kenya National, the Registrar of Companies, the former Registrar of Companies, Honorable Speaker, to get all the relevant information that they may want without requiring manufacturers to go and register with them. Because it may be too cumbersome for businesses. I move.
Honorable members, I propose the question that clause 20 be amended as proposed by the majority leader. Yes, the MP for Kinango.
Chair, I want to support that amendment for simple reason, because asking manufacturers to register with the standards body.
You want a further amendment?
No. I'm supporting
that. You are
that
supporting the amendment?
Yes, because asking manufacturers to register with the standards body, then that of course will increase the cost of doing business. But having said that, Mr. Chairman, is that the issue of registration of products maybe should have been brought into this act, so that then every product that is produced by any manufacturer is registered with the standards body. Thank you, Chair.
Oundo.
Chair, while I can see the intention of the amendment, but this, Chair, is an over legislation. Because nothing stops Kenya Bureau of Standards from getting this information from KRA, getting this information from the registrar of companies or business registration services. And in a case, Honorable Speaker, Chair, let us all go on record, and I hope the majority leader is listening. Any manufacturer of goods and services in this country is registered by Customs under the Excise Duty Act. That information is already there. You do not even need to legislate to get that information. KEBS can just walk there and get that information. Is this just an over legislation? Superfluous? We are just overkill. Basically, nothing stops them.
The Honorable Marianne Keitani.
Whereas I agree with my member, Honorable Undo, not all manufacturers will be registered under the act he's talking about. It's only manufacturers who import who are registered under that act. There are those manufacturers who do not import who will not be registered under that act. So therefore, this amendment by the majority leader is to further buttress that every manufacturer, whether they import or do not import, will be the KEBS will be required, or rather the entities that register them will be required to collect information. KEBS will be required to collect information from them, because we know that all manufacturers will be registered from one source, that is the Companies Act, under the Companies Act, under the New of Companies, Registrar of Companies.
Honorable members. Yes.
For the last time, would the majority leader tell us in just 1 or 2 sentences what is the mischief? Because we are just over legislating. Is there something that we do not know? Could you just tell us clearly the mischief of this legislation? No.
Yes,
I'm asking the honor of the person who has technical information, who I understand.
Any member who has a technical information
I see.
can give.
I see.
Proceed. What is the mischief?
I'm the vice chair of the committee, so I would actually be better placed to give you if there is any mischief. Actually, there is no mischief, but more importantly, if you look at the subsequent clauses that we are seeking to amend, we are requiring that every manufacturer provide information about the products they manufacture because of sampling and because of testing. We are saying that every product that is going to be manufactured must be tested. So for KEBS to be able to undertake that testing, they must know who that manufacturer is. That is the reason for bringing that particular amendment, so that we are able to follow through all the products that are going to be manufactured. And I think that amendment is coming in the next subsequent clauses.
Honorable members, I now put the question that clause 20 be amended as proposed. Will as many of the opinion say aye? Will as many of the contrary opinion say nay? The ayes have it. I now put another, a further amendment. Chair, you have a further amendment. Do you wish to drop that, or you wish to? What is the amendment?
Thank you, Chair. We would like to move to drop our amendment and go as per the amendment of the majority leader.
Okay. Honorable members, a point of record. We don't have a provision for a point of record, but proceed.
One guidance.
Yes.
And I think the minority party whip,
Yes.
Honorable Millie Odhiambo, has been very clear, that a committee, once the committee sits and makes an amendment, any person, be it the chair or the vice chair representing the committee, cannot purport to drop or change the committee resolution without consulting the committee members.
Order.
That's the position. Unless, Chair, the standing orders have changed. Unless the standing orders have changed, the Honorable Chair. The committee, I sit in the Committee of Trade, Industry and Cooperative, and we made an amendment. We made a proposal to amend clause 5, that particular clause. So she cannot purport to withdraw without another resolution of the committee. We signed the adoption report, adoption list. And the adoption list, Honorable Speaker, Chair, was based on the report of the committee and the committee amendments. We cannot come here and change. I mean, we're not a kangaroo court. How? Yeah, there was an amendment. We had an amendment.
Order. We don't micromanage the business of committees. And if authoritatively a chair or a vice chair decides it's going to be dropped, then that's, yes, what, Gishogo? MP for Gishogo, what's your point of order?
Chair, I sit in the Committee of Trade, Leaders and Cooperatives.
Yes.
And Honorable the Vice Chair approached me and the Chair, we were sitting together, and he was able to tell us the intention that is being brought by the amendment by the leader majority. I think the Vice Chair was not able to catch the eye, or Oundo was not able to catch the eye of the Chair for that. But Chair, why we feel that this amendment can be carried by the Chair, it does not obligate the manufacturers to register actually, but the Bureau will liaise with the relevant authorities to get this information, because it is not one of the mandates of the Bureau to register manufacturers under the Act. So it doesn't break any bone for the amendment to be carried.
Order, honorable members, order. I now put the question that clause 20 as amended be part of the bill. Will as many of the opinion say aye? Will as many of the contrary opinion say nay? The ayes have it.
Clause 21.
Honorable members, no, you can't take us back on that. You see, on UNDO, we do not micromanage committees. No. We don't. I think we're past that one. Go ahead.
Clause 21.
I propose the question that clause 21 be a part of the bill. Where is the chair thread? Yes, proceed.
Thank you, Chair. I propose that we delete clause 21, and the purpose for this is that the standards levy should be utilized for the purposes for which it is collected as set out under Order 10 of the standards levy order. So the proposed attempt to channel the funds collected from those functions towards payment of allowances and salaries to directors and staff of KEBS will negate the purpose for which the levy is imposed.
Yeah. Honorable members, I propose the question that clause 21 be deleted, as proposed. Honorable, yes.
And indeed, Chair,
yes,
that was the resolution of the committee.
Yes.
I have no objection at all. And I would want to, we need, yes, because we have done a travesty of justice in clause 20. But clause 21 is in order.
Order. In order. Order. Majority in order. Honorable members, I now put the question that clause 21 be deleted. As many of the opinion say aye. As many of the contrary opinion say nay. The ayes have it. Clause
22.
Honorable members, there's no amendment to clause 22. I propose the question that clause 22 be part of the bill. I now put the question that clause 22 be part of the bill. As many of the opinion say aye. As many of the contrary opinion say nay. The ayes have it.
Clause 23.
Honorable members, I propose the question that clause 23 be part of the bill. The Honorable Chair of Trade, Mayor Kaitani, move your amendment.
Thank you, Chair. I propose that clause 23 be amended as per the order paper, and the justification for that is that the standards of goods imported into Kenya needs to specify actions which KEBS may take to remedy a situation where substandard goods are found in the market, and such remedies could be removal of the product from the market or destruction of the substandard products. And it further goes to require that the Cabinet Secretary may make regulations to give effect to this provision of this particular section. Thank you.
I now propose the question that clause 23 be amended as proposed. Anybody who wants to contribute? Okay. I now put the question that clause 23 be amended as proposed. As many of the opinion say aye. As many of the contrary opinion say nay, the ayes have it. And nay, as many of the contrary opinion say nay, the ayes have it. I now put the question that clause 23 as amended be part of the bill. Will as many of the opinion say aye? Will as many of the contrary opinion say nay? The ayes have it.
Clause 24.
I propose the question that clause 24 be part of the bill. Where is the chair? Proceed, Chair.
Here I am. Thank you, Chair. I propose that clause 24 be amended as it appears in the order paper, and the justification for this is that the proposed deletion of 12A3 on the grounds that accreditation of laboratories is a function of Kenya National Accreditation Service and not Kenya Bureau of Standards. And also this is to require that all established laboratories and calibration facilities, even those belonging to Kenya Bureau of Standards, need to be accredited by Kenya National Accreditation Service under the relevant law. And it is also to require and empower the Cabinet Secretary to make regulation on categories of measuring instruments and equipment. Thank you.
Honorable members, I propose the question that